All right. Well, I think that we are live. Hi, Kate. How are you?
Hey, I'm good. Yeah, I'm happy that it's a new year.
Yes, me too. Happy 2021.
Yeah.
All right. So we had a chance to chat a few weeks ago about the new asylum rule that related to substantive changes for asylum. And so today we're going to talk about some new rules that have since been published and will go into effect in January as well. So for those of you that haven't had a chance to review our Facebook Live on the asylum rule that we did in December, we definitely suggest that you do that. It's going to be a much lengthier discussion that we had on the substantive changes that are coming on January 11th. And if
Mhm.
you happen to have a client who has not yet filed their I-589, the biggest thing that we can continue to encourage you to do is to get that 589 on file prior to January 11th so that they are not subject to the new asylum rule. And we're going to talk about a couple other rules that come shortly after that that you might be able to avoid as well.
Mhm.
Um, so let me pull up the slides.
Yeah, we're
And
in the final week push at my office. It's like getting out all the ones that we didn't push through. When was it? October, August. We had a recent push. So
August, I think. Yeah.
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 So there are a handful of cases that we're trying to push out before the 11th. Final.
Yeah.
Mhm.
And Kate, just to sort of, I know we talked about this in our December discussion, but talk to me a little bit about, so the Trump administration is publishing all of these rules, and I'm calling it the January 2021 death blow. But but they're trying to get all these rules through before the Biden administration comes into office. For the rules that do take effect prior to Biden being able to stop them, how does he go about undoing those? Will they, can he immediately just come back and get rid of them?
No, I mean, the hope is that there'll be some litigation because so much that was contained in the big, some people are calling it the mammoth asylum regs, violate, they've already been enjoined as executive actions, like the transit ban, for example. And what they did is they just published this like garbage can dump of all, as a regulation of all of the policies that Trump tried to push through that either got enjoined or not by the courts. And so I think that, there's still some hope that there's going to be an injunction, in full or in part of the regulation. And like the way that these things tend to flow for those of us who have been practicing immigration for a while, or certainly through the Trump administration, you all know that like we push through, we slam all of our cases through before the filing fees increase or before this or that new policy, and then you do it and then it gets enjoined. So maybe the mammoth rule will be enjoined next week after we've already pushed through all of our applications. But to answer your question is, how do these get rolled out by the next administration? Unfortunately, this regulation has followed the Administrative Procedures Act requirements of publication, notice and comment, and final publication or proposal, notice and comment publication. And any retraction has to follow that same process. So there's at least, if there's no injunction on these rules, there's at least going to be a window of time where they are in play. And you'll see that these cases, one of the big, changes in the regulation that we're about to discuss is the speed of processing of these cases and making them go much more quickly. And so unless the Biden administration takes immediate action to roll back these rules and these policies, there are going to be a significant number of asylum applicants impacted or processed through full decision under these new regulations, which are pretty awful.
Yeah, yeah. So the first of the new regulation is what we'll call the asylum processing rule. And as Kate mentioned, this is often a lot about the speed at which things must be adjudicated. And so that's going to take effect, barring, again, any litigation or injunction, on January 15th, 2021. So that'll be swell here in a few days. So, okay. So
Right.
Kate, tell us about I-589 filings.
Okay, so this is an EOIR rule, so this pertains to defensive asylum applications, people who are in removal proceedings, and you have a series typically of master calendar hearings where in master calendar hearing 1, you respond to the allegations and the charge and the notice to appear, and you put forth whatever relief you're seeking, which would be like asylum, withholding of removal. And if you don't have your application ready at that first master calendar hearing, you're scheduled for another master. And then typically at the second or third master, if you've requested attorney prep time at a previous master, you'll be, at the second or third, you'll be assigned an individual calendar hearing, which is your final hearing. And usually there's like months in between each of these, and sometimes years, because the systems have been so overloaded. So this is a big change that says that the I589, the asylum application, must be filed within 15 days after the first master calendar hearing. Otherwise, the application will be deemed abandoned. And under the Mammoth asylum rules, the judge can pre-termit asylum applications, meaning if it's not like complete, where you've even got maybe some evidence, maybe even a brief, but like full narrative answers to the questions about asylum, the judge can just deny. So this means it's not like, oh, you just have to fill out the 589 and submit a skeletal application within 50 days. You got to like put together your asylum case. And that's really fast. That's a 2-week turnaround, which, after having done these cases for years and years and years, I mean, that's a really fast turnaround to put together an asylum application, let alone evidence application and legal argument.
Yeah, and a lot of people have attorneys at their first master calendar hearing.
Do they? No, no, that's actually a great point. No, many of them go to the first master calendar hearing. They ask for more time to find an attorney. It takes them a week or 2 to get a consultation. I mean, it's like, yeah, if they've gone, pro se to their first master, it's almost impossible that an attorney is going to be able to get it in under this deadline. And I don't know what this good cause exception would be. Maybe the applicant is hospitalized, for 15 days.
Right.
It's gotta be.
I'm sure it's going to vary a lot depending on the judge.
Right, but almost no judge is gonna be like, oh, it just took you that long to get a consultation with an attorney, or it took you that long to get in, with the nonprofit organization that's assisting you now. My guess is that won't be deemed good cause for a delay.
Yeah, I think that's probably right.
But just like the Mammoth rule and most regulations, it's not retroactive. So this is applying to cases after January 15th. So we do have 2 weeks, to not fall under these new rules.
Right. And so this is specifically for cases initiated after January 15th. So it's not for I-589s filed. This fortunately is not part of the reason that you have to rush for the January 11th deadline.
Right. And I don't know specifically in the regulation, the date of initiation. My guess it would be the date of issuance of the notice to appear.
I would think that based on the definition of when proceedings commence, it would be the date that the NTA's the notice to appear is filed with the court.
Right.
Yeah. Okay. So submitting proof of payment. So there was for a moment going to be a filing fee. So asylum applications have historically been free. And then USCIS published a whole bunch of fee increases, including creating a new fee for I-589 applications, which has since been enjoined. But I guess they're hedging their bets that filing fee is going to come back, because part of the new rule is that you must submit proof of payment. So the crazy thing about that is that in order to submit proof of payment, you have to mail the first 3 pages, I believe, of your asylum application to USCIS with the payment, and then you get a receipt notice back. And I mean, at least with a lot of USCIS receipts, it's taking months to do that. So how are you going to do that within 15 days of the date of your master calendar?
I mean, I can't imagine that anyone's going to be able to prove it with a receipt from CIS. There's no way they'll get the turnaround. So you'll have to like attach a copy of your money order.
Mailing. Yeah, I would think so. All right. Effective codification of the blank space rule. So Kate, tell us about the quote unquote blank space rule.
I mean, this rule is such a headache, and there have been like so many memes, in the immigration lawyer groups about this, like that you have to, every immigration form has a ton of different blanks that you fill out, and many of those are not applicable. Like maybe they have a section for kids and you only have one kid, but they've got like 7 blanks, where you're supposed to fill out all this information. So the rule is that you have to fill out every single blank space with an NA. With a not applicable, and that if you fail to do that, your application will be rejected. And so under this rule, if you get a rejected packet, then you have 30 days to resubmit it, or it's going to be waived. So I hope that means 30 days from the date that you received the rejection, because we certainly in my office have had rejections that can take weeks or months to get back to us. And so, but they just mail them regular mail. And so I don't know how they're going to manage that 30-day window, because the date of delivery is not going to be registered like with the post office, for example.
Right.
It's going to be if it goes by the date of rejection and you only have 30 days, that's a huge problem, because it has taken us more than 30 days just to get rejected packets back. And that's from the date they mailed them. Like, I think that they hold on to them post rejection before they put them in the mail.
Yeah, or they just get set somewhere and they get forgotten. And no, I definitely think that can happen. I had a case recently. It was a little different issue where I had the Board of Immigration Appeals had sent me a briefing schedule to my old address, and I didn't get it until the day before the brief was due. And luckily, I was able to find, because I have like a stamps.com account, I was able to find proof of delivery of my change of address from 2019 that I had sent to the BIA. And so I filed an extension with the proof that I had sent them a change of address in 2019. And so they had sent it to the wrong address. And I objected. They filed an objection to my motion for extension of time. It was wild. Anyway.
Yeah, this is lawyering in this era. Here's hoping that things are going to get better next month.
Yeah. So this applies, the determining for completeness applies to all applications filed on or after January 15th. So again, with the January 11th deadline for asylum applications, this is something that would matter, where you want to get your asylum application in right away to avoid this as well.
Although I've been practicing this way. We have in my firm for years. I remember an I589 got rejected that I worked on like 5 years ago, maybe, a few years ago. And where you had to list all the siblings and their location. And we put like deceased for one of the siblings and didn't complete the location. Because they're deceased, and like it got rejected. I mean, it's just, so after that, we were like, all right, no blanks ever on 589. So if you've been practicing this way for a while or doing asylum applications, you have probably had a
already blanks. Yeah. But I mean, for pro bonos where, it doesn't apply. And so they just leave it blank. Like, it makes total sense. Yeah. I heard of someone else having that, where they had written deceased and then they got a rejection for not filling in the location. And so they put heaven, hopefully.
That's clever. See, I never get snarky like that. You really want to just get super sassy when you respond to these rejections, but I always just like,
yes. I mean, come on now. Yeah. All right. So the required adjudication timeline. This to me is maybe the scariest thing, especially when you couple it with now the ability of immigration judges to pre-termit from the other rule from our other conversation back in December, to be able to take an asylum application on its face and say, this isn't legally sufficient. And so I'm not even going to give you a trial. You're just going to be deported. And so when you couple that power with this timeline that they have to adjudicate all of these cases, I mean, they're going to be super motivated to just
pre-termit.
Yeah,
for sure. And the other thing to keep in mind is this doesn't mean like, oh, you're going to have 6 months. When you file the asylum application, then you can have 6 months. And like we need this time, right? We're looking for experts. We're preparing our testimony. We're getting all of our evidence, because you typically don't submit your packet until about a month before the final hearing. And we're talking like hundreds of pages of country conditions research and reports and evidence. It's not like you're not going to submit your asylum application and have the judge go, okay, well, we've got 180 days. So how about in 160 days, we schedule your individual? It's going to be like, okay, I've got you. I'll have you back in 2 weeks. So all this means is that they're just going to either pre-dermit and just deny based on the application, or they're going to just push us through as fast as possible. And we're going to be scrambling.
Yeah. One thing I will say that just when thinking through, so Biden has also, and we did a Facebook Live on this, probably a couple of months ago now, but has talked about what he wants to do in the first 100 days. I mean, I guess a consolation there is that, he intends to keep a lot of asylum cases that pass their credible fear interview with the asylum office and not with the court. Now, I don't know in what manner he plans to do that. But I'm just processing through all of this because it sort of went through my head that he also said he wants to like double the number of immigration judges and court staff and interpreters. And so as all of that comes into play, hopefully some of this won't be, and hopefully, of course, he overturns this rule or publishes a new rule to invalidate this rule.
Right.
But I wonder how quickly he can get it where some of these cases are out of the court.
I don't know. And I think for those of us watching who maybe aren't doing this as a practice area, but you're interested in these issues, one of the important pieces of advocacy is going to be holding Biden to his word, because as we know, immigration is such a divisive issue that it would, I think, be really easy for the new administration to say, like, we've got a pandemic, we've got an economic issue, like we're going to focus on those. We're not going to touch this, immigration stuff. And so I think we really need to hold them accountable to what they've said they're going to do. And it's a lot, honestly. Undoing the mess that Trump has made of the asylum process it's a huge, huge job. And so I hope they get to work quickly and go through this, all of these.
Yeah, me too, for sure. I hope so. Okay, so this is weird. So judges generally are supposed to be neutral finders of fact, right?
Right.
And I guess just as an overview, in case some of you don't know, immigration judges are not normal judges. They are under the Department of Justice, which is run by the executive branch. And so their boss is the attorney general, who is appointed by the president. So generally hasn't been super neutral over the last 4 years. But this is a new level where immigration judges will be able to submit their own evidence into the record.
I know, it's like crazy if you try and like place this into the context of like a criminal, like a prosecution or even just a civil case. I mean, people are just like, wait, what? But, those of us who have been to individual hearings, there are, of course, those judges who, most of whom were DHS attorneys before they became judges. And you can feel like you've got two sets of opposing counsel when you're in a hearing, and because the judges will interject and they'll do their own cross-examination, but now they'll be able to also turn in packets. So,
yeah, right. Submit their own evidence.
Right.
I wonder if they have to follow the practice manual by double putting tabs. Okay, weighing of evidence. So one of the things that I find really interesting about the way this is worded is it talks about admissibility of certain sources, which to me is very odd compared to just how much weight you should give a piece of evidence, because in immigration court, the rules of evidence are relaxed. And so generally, in terms of what is actually admissible, I mean, it's whether or not it's relevant, right? I mean, in most cases. So this is really interesting to me, and it'll be interesting to see what like future guidance is published. But it's a little bit scary to think that some things that we have relied on that are genuinely, good sources of information might now be deemed, just that we can't admit them.
I mean, I can almost like picture, like the memo is gonna like have references to like the liberal mainstream media, or something like that.
Cannot submit a
No,
CNN
wait.
article. Right, right.
Because yeah, I mean, like you said, it's all admissible. And judges should be able to make their own determinations about the weight to give certain items of evidence. But we'll see what these instructions are, and when are they going to do them? Okay, so this is like 5 days before Trump's presidency ends. So when are those instructions going to come?
Yeah, that memo's coming next week, probably.
Right.
Yes, I mean,
Oh man.
yeah, I mean, and I've had an asylum case where the person was from such a tiny little town, and I mean, the government is corrupt. Like most asylum cases, you're at least arguing on some level that the government is involved or is aware of what's going on. And so, a lot of newspapers, like, the more mainstream media are not going to be publishing this. So I've done it where I've submitted a bunch of Facebook posts because it's like, that's the only thing, some blogger is talking about what's happening in this tiny town. And there's just no other source of information. I mean, there's just not. So anyway, that'll be interesting to see it unfold.
Right.
Oh, the third country transit ban. Here we are again.
Yeah.
So
yeah, I mean, we've covered this one. I don't know why they're including this separate from the Mammoth regs. I guess because they're just reiterating, they're just doubling down in the EOIR memo that.
Yeah, or they couldn't cure the defect fast enough. I mean, I don't know. Like, so the district court decision that vacated the interim final rule did so based on failure to follow the procedural requirements in the Administrative Procedures Act. And basically now the Department of Justice and the Department of Homeland Security are arguing that because they've published this rule and considered comments, that it cures that defect. And so that doesn't apply. And then the Ninth Circuit injunction was stayed. And so they're saying that basically, barring any additional litigation and court order, that the third country transit ban is going to go into effect on January 19th.
Which is a death knell to anyone who has not flown directly into the United States from their country.
Right. So anyone who has traveled through Mexico to get to the United States is going to be barred. If they have not, if they have not applied for and been rejected asylum, or they have proven that they merit asylum from that third country as well.
Right.
So anyway, we won't go into that too much more, but there it is. And just FYI, so the weighing of evidence, this stops, it's a separate rule. So all of the things we've discussed up to this point are a separate rule, and then the third country transit bans its own rule, and then our last rule is also its own rule. And so this is the security ban for communicable diseases, which is really just one other way to keep people out. So you want to talk a little bit about this one?
Sorry, I had to look at something else on my screen. I was getting a message.
No, you're good. So this expands the statutory bar for asylum and withholding for individuals who may have been exposed to a communicable disease, including COVID-19. So they apply this in expedited removal proceedings. And so, when folks, before MPP, it used to be that people would come to the border, ask for asylum, and get what's called a credible fear interview or potentially a reasonable fear interview, depending on your circumstances. But if you are subject to this bar, then you don't just get a credible fear interview, do you have a significant possibility of winning asylum? You go immediately to a much higher standard of more likely than not that you're going to suffer torture at the hands of or by acquiescence of your government. And so now, it's just, again, another way to change the standards and bar people from entering who are fearing for their lives.
You covered it. I got nothing else to say.
I know. Here we are. So Kate, in terms of takeaways, if you're an attorney with a pro bono case or with an asylum case, what are the big takeaways?
File 589s before next Monday, January 11th. Stay tuned on Vicina and, other outlets about injunction litigation. And then if you are in removal and you're representing someone whose case is initiating post January 15th, right? Obviously, you don't file their 589 before next Monday because that's the 11th. But if you open up a case or a matter, or you come into contact with an asylum seeker after January 15th, you've got to keep that 15-day deadline in mind and know that even whatever case you accept or take on is going to be processed very, very quickly. So you have to be ready to hit the ground running on those cases.
Definitely. All right. Well, thanks for your time today. We hope everybody's doing well and have had a great holiday, and we'll be in touch probably over the next few weeks as we get these memos that are supposedly coming, and on a positive note, as Biden takes office.
Exactly. Like, let's make our next video after Inauguration Day where we're announcing the next fun thing that's happening, like the good news, presentation. Because honestly, I'm tired of doing these bad news.
I know. I think what we got to do is we got to get champagne after he signed the first set of memos that are related to immigration, and we're just going to be like, here's all the great thing that's happened, and now we're going to have champagne.
It's spraying it everywhere. Yeah.
It's a date. Exactly. Awesome.
Okay.
All right. Well, have a good night.
Bye, everybody.
Bye.